Welcome, everyone. Give me 1 minute. I'm trying to get the Instagram going here. Okay. Welcome, everyone, to Notable Approvals. It's been a long time since I've been able to do a video. We've been quite busy. But this case, I have been waiting a very long time to talk about. So I'm really excited to get to it. So let's do it. This client, there's actually another video that I did about her after we had initially gotten her case reopened during Trump's first term. I don't remember. I can't even remember anymore. My brain's a little mush right now. We just finished court, and she now has a green card, which is spoiler alert. But I will try to link that video to get some more background on the case, but I'll give a kind of an overview of everything right now. So this client is a native and citizen of Trinidad and Tobago. She entered the U.S. in the year 2000, with a B2 visa. In 2007, she married a U.S. citizen and obtained conditional permanent residence. He obtained that in 2007. However, and unfortunately, her husband was abusive towards her, and he had a history of drug and alcohol abuse as well. She initially hoped things would improve with him, but unfortunately, the abuse escalated. So they separated. In 2009, she filed, well, they weren't separated yet. They will separate. In 2009, they filed a joint I-751, which is a petition to remove conditions on your green card or to get the 10-year green card. In 2010, they attended the green card interview together, but her husband was intoxicated and was unable to answer questions, which ended up resulting in a denial. I feel like I'm not in the center here. Okay. So she needed help, and she was told to go to this guy who she was told was a USCIS officer. And he ended up filing fraudulent documents without her knowledge, which caused her to get a notice to appear in 2011. I actually think that is, I just said that backwards. In 2011, she was put into removal proceedings, and she was asking around for help. She was directed to this person she was told worked at USCIS and could help her. And he's the one who said, "Oh, I can file something for you. No problem." She didn't know what it was. So what happened was he falsely told her that she didn't need to go to court, even though she had a hearing, because they filed a new I-130 petition, or alien relative petition. Now, just for everyone out there watching, you like today, there's some instances where you don't have to go to court if you have a lawyer, but this person wasn't a lawyer, and the lawyer is attending for you. But if there's any doubt, go to court, because for the most part, you do need to be present, unless the lawyer has told you that I filed my notice of appearance, it's virtual, and the judge said you don't have to go. And then you check with the lawyer right after court to see, okay, well, what happened? Can I have the paperwork? So when she realized that the documents he submitted were fraudulent, because they sent it back and said we need more evidence, she ended up saying, I'm not doing this. I didn't know it was fraudulent, and she didn't. She never sent it back. But because she missed court, she was ordered removed in absentia. And that meant she had a removal order in 2011. So she hired an attorney pretty quickly in 2011, and he filed a motion to reopen, but failed to show all of the proper requirements under matter of Lozada, which is a case with the Board of Immigration Appeals that says how you claim an ineffective assistance of counsel, make an ineffective assistance of counsel claim, like all the steps that you need to go through in order to make a valid claim. So he didn't go through all the steps, so it was denied. What was strange was that motion to reopen was granted, but then DHS filed a motion to reopen, which was also granted, or a motion to reconsider, I'm sorry, which was granted. And then so basically her case was reclosed. Because basically the DHS said we never got the motion to reopen and we would have opposed it. So the judge ended up they only reopening it because it was unopposed. And then when they did oppose it, it got denied. So then she found a new lawyer who filed an appeal to the BIA, or Board of Immigration Appeals. And that was denied in 2021. 2012. Geez, 2012. Because again, the attorney did not follow the Lozada requirements. So that lawyer then told her, you don't have any options. I can't help you. So then she was referred to someone that some of you out there may have heard of, named R. Lee Lewison. R. Lee Lewison is not a lawyer, and I believe he actually passed, but he posed as a legal advocate for domestic violence victims. And she actually met him at her church. He said he was going to help people for free, which if someone's going to help you for free, unless it's a legitimate nonprofit, always question that, because nothing in life is free. So he ended up filing 3 fraudulent VAWA petitions. VAWA stands for Violence Against Women's Act. Can be filed by men or women, and it's for spouse, children, or parents who were victims of abuse at the hands of their U.S. citizen or permanent residents' relatives. So between 2012 and 2016, 3 different VAWA petitions were filed, and they were fraudulent because they did not include the documents that were needed. And he never explained to her why they got denied. He just kept refiling it. So when the 3rd time came around and it was denied, he stopped answering her calls. And that was when she's like, okay, I need to find someone else. And then she finally found us in late 2016. And when we took over the case, we found multiple problems, all the problems and more that I mentioned. It turned out USCIS had sent a request for evidence for the VAWA application to get more evidence, but the client never received it. And so we didn't even know what they wanted. So we had a request for it to be resent. And when we received it, we filed a proper response. Then when we were asking her about her removal proceedings, she thought that her case was closed, not that she had a removal order. So I ended up reviewing the record, going to court, sitting there listening to the tapes of what happened, and going through her file and figuring out, okay, you have an absentia removal order, and your case is with the BIA, not with the immigration court. So basically, I had to, after we got the VAWA approved, which was pretty quickly after we filed the response to the request for evidence, and the VAWA basic requirements are you have to show you had a real marriage, you didn't marry for a green card, and that you're a victim of domestic abuse, and in this case by her spouse. Lambert, thank you very much. You're welcome. Thank you for joining us. This is a good one, Lambert. So where was I? Oh yeah. So basically, as soon as the VAWA got approved, we had to start preparing to file a motion to reopen with the Board of Immigration Appeals based on ineffective assistance of counsel. So based on the same grounds that 2 other lawyers tried to do already and failed. And we had to argue now not just that there was 1 layer of ineffective assistance of counsel, not 2 layers of ineffective assistance of counsel. 1, 2, 3 layers ineffective. It might have even been 4 layers altogether, if I'm remembering. But that other video goes into a lot more detail about that, which I said I will try to link to. So we had to prove that each one of them failed along the way. Now, the other thing is you can't just get a removal order and sit around and wait for 10 years and then say, oh, I'm going to go see if I can get help. And it turns out you can get help, and now you file a motion to reopen. There's time limits. So we had to also prove that the time limitation should be told. What that means is that basically she gets an extension of time because she really was acting diligently every step of the way. She kept going to new lawyers or paralegals or whatever you want to call them, who unfortunately kept failing her. And even when she got to us, like, she had been filing those VAWA applications for years and had no idea why. Yeah, it was at least 4 layers of ineffective assistance of counsel. So we had to argue that all these lawyers and paralegals failed her, and it prejudiced her case. She would have gotten approved otherwise. She acted diligently, like I said, and that she's eligible for relief. So by this time, she did have her approved VAWA petition, and she was eligible to adjust her status. She entered with a visa, although for VAWA, you don't necessarily have to. And it was in her own name, no criminal history, etc. So in April of 2019, we filed a request with the Department of Homeland Security asking them to join us on a motion to reopen, which is very hard to get them to agree to. And if they did not agree, the chances of the BIA reopening her case was going to be minimal. But they did agree a year later, in April of 2020, which was very excited. And it took the BIA 3 years. 3 years. So February 2023, they finally granted the motion to reopen. Even though the Department of Homeland Security joined us on the motion, they signed it and everything. It still took 3 years. So once the BIA reopened her case, they had to remand it back to the immigration court because they're an appeals court, and this had to go back to the trial level court. And so it gets remanded. So we had a discussion on whether should we file a request for prosecutorial discretion or wait to have the case go before the immigration judge. Her case was scheduled pretty quickly for a master hearing, for the first court hearing in March 2023. So we said, you know what, let's just go to court, see what the judge says, because this was a straightforward case. She should have been approved. It shouldn't have been any question. We requested an expedited hearing for the final merits case, and the judge granted that request and scheduled it for June 2023. So after that March date, we updated her green card application because that had been filed. That was part of the appeal or the motion to reopen. We had to file the green card application. So it had been filed already. She needed to get a new medical exam, but everything else was the same, just updates. So June 2023, my client came to my office. We were waiting to be admitted to virtual court, and we don't get let in, only to find out shortly thereafter that all of the judge's cases that day were canceled, and no one told us. So that was frustrating. So then we had to sit back and wait. Well, when's the next court date going to be? So client called and we check, and it says, all right, hearing was moved to April of 2024. So we're like, all right, let's file another request for PD or prosecutorial discretion to get things moving quicker. And the way we do that is by asking them to join us on a motion to expedite, and also by saying, hey, can we agree that this person is eligible for a green card? We can do it on the papers and submit it to the judge, and the judge can sign it. That's very rare that you'll get DHS to agree to that, but in situations like this, it's usually worth a try. So after we filed that PD request, which by that time, it was taking a very long time to process them, like taking a year, we checked her case status again, and she was no longer scheduled for any hearings. Like, her case was closed, like administratively closed. But we never received a notice or a request, and there was no reason to administratively close her case. She's eligible for a green card. So we had to file. Well, first I contacted the attorney in her case for the government, and they agreed to reopen and remand her case to check on the PD request. I don't know if I wrote that right. I asked them to check on the PD request, and if they would basically agree to dismiss her case so she could get her green card with USCIS or get the case on the calendar quickly. This was the same, we call them trial attorneys or TA for the government, who joined us on our motion to reopen, which was, again, something that is rare that they'll do. So when I asked them, okay, they only will agree if they believe she's eligible for the benefit for the green card, I was like, okay, well, we're at this point. The court, I don't know what's happening with court. Will you agree to dismiss it? And he said no. And I'm like, what do you mean no? You agreed before. I don't see, she has no criminal history, no inadmissibilities, nothing. Like, why wouldn't you agree? But he would not tell me why. And they were not required to tell us why. So that we were very frustrated and had to file a motion to recalendar. So back in March of 2025 of this year, we were scheduled for an individual hearing yet again. And we get there, and now we have a new trial attorney. And this guy says that the background checks weren't complete. And we were like, what do you mean the background checks weren't complete? Which is, honestly, that happens a lot, and it could be for many reasons. And he said, well, we have questions about her marriage. Oh, just some thunder out there. Ooh, that was scary. He had questions about her good faith marriage to her husband, who was abusive. And I was like, hold on. When you file a VAWA petition with USCIS, there's one, I don't know if they opened a second, but I believe there's still only one office in the country who can make a decision on your VAWA petition, and that is the Vermont Service Center. And once they make that decision, unless there's something outside of that, basically DHS cannot come back during court and say, well, we don't believe the marriage is real. There's very little they can overturn there, and we're not even required to give them the VAWA application or any of the evidence because there's privacy concerns with it. And the office in Vermont is specially trained to handle domestic violence cases. So the law doesn't want someone who's less trained making these decisions, and that's why the law is the way it is. So I was just flabbergasted. I could not believe that I was hearing this from DHS. It made no sense, because if they weren't going to grant her the green card, why reopen her case and waste court time and waste everyone's time? The court has plenty of cases today. Today, the judge, we were supposed to have our hearing at 1. We didn't until 3:30 because the judge had 99 cases this morning. 99. They started probably before 9 a.m. and they were still going when we signed in at 1, and then we're told to come back at 2:30, and then we started at 3:30. So they had a lot of cases, and it just didn't make any sense. And it was just really, I cannot explain the frustration for someone, every time clients are in this position where even when they have a good case and like I'm assuring them they're going to be granted, it's still stressful and they don't sleep the night before. And, there's a lot going on in the head, of course. And it's really difficult. And it's difficult for me too, because I get, pumped up. I'm ready to go, even though I knew this wouldn't be a battle, but I was ready to go as soon as they brought up the issue of the marriage, because I was like, no way, pal. It was a legitimate marriage. It's already been proven. And and there's just not a question there. So the judge, he felt bad, but he was like, if I don't give them the opportunity they can't do it if they're claiming the background checks are not complete. They can't start the individual hearing. So his hands were kind of tied. And this is actually a very nice judge who I've had a bunch and I really like. But he had no choice but to reschedule it. So her medical exam was going to expire in May or in June. So he said, all right, let me reschedule you guys for May so you can come back quickly. The government said that's plenty of time to look into it. And between March and May, the government attorney confirmed to me, hey, we finished our background checks. We have no issue with the marriage. So I said, okay, great. Can we dismiss the case? And once again, he said, we can't dismiss the case. We want to ask a few security questions. Fine. Okay, well, we have court soon. However, out of nowhere, the case got rescheduled again until November. And, at this point, it was like getting a little ridiculous. I didn't even know what to tell my client when I saw the notice that it was rescheduled. So we told her, look, we can file a motion to advance again. I will ask DHS to join us. And if they join us, the judge should grant it. If they have a time slot, they'll put you in. Worst case, we have to wait till November. So I did exactly that. The DHS joined us on the motion to advance. And they said it would only take like 30 minutes. So a lot of times judges can fit those in, after master hearings or before. And the judge thankfully granted it and scheduled us for today. So today, we were happy that when we logged into the courtroom, there were people there. That was number one. And then when I saw there was a master, I entered my appearance in the chat, and the government attorney reached out to me and said, I'm going to contact the judge privately so he knows you're here. And then he then called me and said, called me on the virtual court and said, we're finishing the master, come back at 2:30. So we did. And I was a little nervous that we were going to get pushed again to another date because they were going to run out of time. So I was kind of holding my breath this whole afternoon. I mean, I'm exhausted just because I've been waiting, not because the trial was hard. When we finally got to go before the judge, I spoke to the government attorney right before, and she's like, I only have a few security questions to ask. So I was like, okay, you can go first, because I didn't have any questions to ask because I had no doubt she was admissible. So they only asked her some very basic questions, and it was actually nice. The government attorney said, just so you know, these are questions I ask everyone. This is not saying anything about or applying anything about your case. Again, not something you hear often, but the way my client was treated today as compared to all the other times, like especially right now, with what people hear about what's going on with immigration court and everything, if anyone deserved to be treated a little bit nicer at their individual hearing, it was her. So we got lucky with the judge, we got lucky with the trial attorney at the end of the day. But the fact of the matter is, like, she's been through hell and back, and I've been along with her on the ride for many, many years. And it's frustrating when you get all prepped and you're ready to go, and then you're like, what? You don't have court, and then you don't know when it's going to happen. So they asked a few questions, and that was it. And the judge said, do you have anything? I said, nope. And the judge was not only said that he was granting her application, that she is exactly the kind of person that deserves it. He cited her work with she's part of an organization that helps people. She big part of her church. She's been working and paying her taxes this whole time that she's been in the country. And he encouraged her to apply for her citizenship in 3 years, because even though it was a VAWA, her spouse was a U.S. citizen, so she is eligible to file in 3 years. And I've never actually heard a judge, at least that I can recall right now, say to a client that you are exactly the type of person who deserves this. And honestly, I couldn't agree more. Like I said, I've known this client for a very long time, and she's really just a sweet lady. She never got angry, she never got impatient, and she's been through the ringer. I mean, it was like everything frustrating that can happen in a case pretty much happened to her. So the last step, really, for her to get the green card now is for the case to be transferred to USCIS, which I don't do, the government attorney does, for them to produce the green card. So fingers are crossed for her that that part goes smoothly, because if you've seen some of my other videos, it doesn't always go smoothly and has nothing to do with her or anybody else, except that we're dealing with gigantic paper files where there's millions of open cases. So I've seen it all. So I never get excited until the person has the green card in their hand. But what I can say officially is that as of today, no matter what we're talking about getting the official green card, as of today, she is a lawful permanent resident. Her green card will be dated July 1st, 2025. And like I said, 3 years from now, she will be eligible for her citizenship. So the biggest takeaways of what happened today is, number one, immigration court it can be really frustrating. The process, we all know that. I mean, I don't even need to say that. But this is an example of patience and perseverance and really having belief that it will happen, really kept her going. She spent God knows how much money, and not just to us, but to those other people that were committing fraud, like, against her. So, you know, if you really are eligible and believe, you just got to keep going. I mean, what's your alternative? You know, is gonna she's still got plenty of good years left in her life, and she's gonna now have a much easier time. The other thing is, you know, be careful out there. There's a lot of people out there that have bad intentions and that are just looking to make a quick buck and will scam you. And, you know, look up anyone who is a licensed attorney in the United States can be looked up online. You find out the state they're licensed in, and you go New York attorney lookup, you type in their name, and they should be registered in the state they tell you they're registered. Paralegals are not the same things as attorneys. This client legitimately did not understand that until later on in her case, basically until she came to us. When she came to us, we were like, why didn't you go to a lawyer? And she was like, I went to a paralegal. We're like, but that's not a lawyer. And she's like, oh, I thought they were the same. And that is honestly a common misconception that we get from clients. So be very, very careful. Go to your court date, especially if you have any doubt about whether you should show up or not. I have most of my clients, even when we say that it's virtual, you don't have to attend, the court excused you, they'll still come, or they'll log in on their phone or computer at home. And that's perfectly fine. It's better to show up and not need to be there than to not show up and need to be there and get an order of removal in absentia, because that is one of the hardest things to reopen, especially when it takes all these years. So this is one of cases I'm really, really proud of, because of how hard it was. And I know my client's going to watch this video. She's probably on her way home right now. And I want to thank her for her patience and her trust in me, because there was a lot of me having to tell her bad news along the way. There was good news, but also bad news, and all the delays. And some clients are less understanding that it's not my fault than others. So I do appreciate that, her trust and her faith in me. And like I said, if you're out there and you're in a similar situation, keep on moving forward. And of course, if you or anyone you know has any questions or needs representation in your immigration case, our contact information has been scrolling across the bottom of the screen. We would be more than happy to help you. And especially these hard cases, these big cases, and with all this history, they're tough. They're exhausting, but they are by far, to me, the most rewarding, because getting this win, which I'll just, not to brag, but I got her case reopened during Trump 1, and I got it granted during Trump 2. And that is definitely something to be proud of. And you're not going to hear a lot, unfortunately, about that in the next next 3 years, whatever. So that being said, that is all for today. I will do my best to link the other video if you wanted to hear a little bit more about her case and how we did it, the early stages. I've just been, it's been a busy time since January 20th. And again, please reach out to us if you have any questions about your own case. We are here for you. Thank you all for watching, and have a great day.